Hello, everyone, and welcome to today's webinar on developing a sound global trademark filing strategy. My name is Graham Hood. I'm a principal in the Toronto office of Smart & Biggar, and I'm the firm's trademark practice group leader. My practice spans all areas of trademark law, from clearance and prosecution to enforcement, including anti-counterfeiting, and even trademark litigation. Today, I'm joined by my colleague, Olivier Jean-Lévesque.
Hi, my name is Olivier. I'm a senior associate at Smart & Biggar in the Montreal office. I've been with the firm since 2016, and my practice focuses on trademarks, domain names, and geographical indications. And in those areas, I do a bit of everything, so from prosecution to strategy to enforcement and a bit of litigation as well. So happy to be here.
Our firm, Smart & Biggar, is Canada's leading IP law firm. We are Canada's largest and one of its oldest IP firms with expertise in all areas of IP. We most recently joined forces with another preeminent firm, Bereskin & Parr, which joined us in September 2024. Our firm now boasts over 180 lawyers, agents, and technical consultants with offices from coast to coast in Vancouver, Calgary, Waterloo, Toronto, Ottawa, and Montreal. Smart & Biggar is part of the IPH Group, a leading international IP services group covering 10 secondary markets around the world under the banner of 7 exceptional brands. We thank you all for attending today's webinar, and we're thrilled to be sharing our insights with you today. Before we dive into the content, I'd like to start with a few housekeeping details. Our formal presentation will last for about 30 minutes or so. Will then be followed by an open and interactive Q&A session. You're welcome to submit questions at any time during the presentation by clicking on the Q&A button at the bottom of your screen. We'll try to address as many questions as we can during our live session. This webinar is being recorded, so after the session, you will receive an email with a link to the recording, along with a PDF copy of the slides. At the end of the webinar, a survey link will appear. We would greatly appreciate your taking a moment to share your feedback on today's session and let us know of any other topics you'd like to learn about in the future. With that, we'll now take a look at the key topics we'll be covering today. So today we'll be talking about developing a sound global trademark filing strategy. And why do you need a global filing strategy? Well, we live in an interconnected global economy. Leading brands' reach spans multiple jurisdictions. Rarely do you see a business that operates entirely and solely in one jurisdiction. And infringers and other bad actors do not respect borders. Brands that may be doing well elsewhere may be ripped off in another jurisdiction. So a global filing strategy equips brand owners with a sword and a shield. A sword to enforce rights abroad, and a shield to defend against threats from competitors and protect one's brand and brand identity both at home and abroad. So most brand owners must protect their brand not only on home soil, but elsewhere. And over the next 30 minutes or so, we'll share with you some tips, tricks, best practices for protecting your brand both at home and abroad. At the very core of developing a global trademark strategy is this challenge of balancing 3 separate but interconnected issues. You need to maximize protection across the jurisdictions of interest while managing risks such as obstacles to use and to registration in domestic IP offices, and also managing costs related to searching, filing, and maintenance. These are the 3 goals of any sound filing strategy, but of course resources are finite. We have limited costs, we have limited time, business resources, including executive bandwidth and people power. So we're here to share with you some best practices for balancing these 3 issues. So today we'll explore 3 essential steps to getting towards a sound global trademark strategy. determining key parameters, conducting trademark clearance searches, and taking advantage of multinational filing systems. The first step in developing a sound global trademark filing strategy is determining your key parameters. Now, it's never too early to develop a brand. Taking the time to carefully consider how your new brand fits into your overall business objectives is critically important. You have to ask yourself, what do you plan to accomplish with the new brand? Why? How does it fit into the overall scheme? You want to ensure that your strategy aligns with your overall business objectives and accordingly determine the key parameters of your trademark applications. So what are some of those key parameters? Well, first of all, you'll need to look at the key trademarks. What is the trademark that you wish to protect? Is it a primary trademark? Is it a secondary trademark or sub-brand? Is it a tertiary trademark, say a slogan or tagline? And where does that new brand slot into the hierarchy? You have to ask yourself, what is the trademark of interest? Are you looking to protect a word? Are you looking to protect a design, a non-traditional mark? As of 2019, Canada's scope of now registrable marks has expanded considerably, and provided you can demonstrate distinctiveness as of the filing date, you could theoretically apply for and register as a trademark a sound, a color, a texture, the positioning of a sign, a moving image. The list goes on, but of course you need to demonstrate distinctiveness. You also need to consider, how will you deploy your mark? Where will it appear in the market? How will it be used online, on pack, on signage and advertisements? All of this will affect how you choose your mark and ultimately the subject matter of your application. You also need to bear in mind whether you'll use the mark in other languages, in other jurisdictions. Will you use translations or transliterations in Quebec, for example? Bill 96, which is a new law that has been rolled out in Quebec, has posed a new set of challenges for brand owners. The bill requires brand owners to translate non-French inscriptions on products, including descriptive or generic language that may be part of a registered trademark. And so it's important to bear in mind these French language requirements when putting together your filing strategy. If a brand owner owns a registration of the French version of a mark, they must use it in Quebec, no exceptions. So in preparing and putting together your filing strategy, consider whether you're filing in both French and English, or only in English, only in French. It'll depend on the markets of interest and where you see your business growing in the coming years. When it comes to the marks themselves, at every opportunity, I advise clients to file for basic word marks instead of stylized versions. Basic word marks afford brand owners the broadest scope of protection. Upon registration, they protect use of the mark in any color, in any style, in any typeface, whereas stylized versions hew to the applied for version. Stylized versions can also pose problems down the road in cancellation proceedings if a third party seeks to challenge the non-use of the stylized version of the mark, and you may be using it, but in a different style or a different typeface. That could pose challenges, as that particular style or typeface may not support the mark as registered. Another key thing to consider is color claims. You have the option, of course, of claiming a color when you apply for a trademark, but that serves to narrow the scope of protection. If you claim a color in connection with a word mark, say it's only protected in red, well, then the scope of protection is narrowed somewhat. I always recommend not to include color claims unless you, the business, are married to that particular color. You see it as a source identifier and a key component of your brand identity. So here's an example of a trademark and an example of some of the considerations to bear in mind in determining what to file for. So with a name like this, would we file for a basic, smart, and bigger? A stylized version, such as what you see here? Would we apply in color or no color, which would afford broader protection upon registration? Tagline says member of the IPH network. Do we include that in the filing or do we exclude it from the filing? Again, it will depend on how we plan to use the mark in the future. When we see it on signage, online, on pack, will it always be accompanied by that tagline? If so, then perhaps it's best to include it in the filing. But if not, if there'll be variations of the use of the mark, perhaps it's best to leave it aside, or perhaps file for that tagline separately. And then clearance issues. Once you've identified what you want to protect, it's a separate step to determine whether you can in fact protect it. Next, turning to the goods and services. Another key parameter. What are the goods and services of interest? We encourage clients to take the long view. Consider the goods and services you're offering now, but what are you likely to offer down the road, where you see the business going in 3-5 years from now? Where do you see the industry going during that time period? What are your competitors doing? Because it's easier, faster, and overall less expensive to prepare and file an omnibus application that covers all the goods and services of interest. So-called extension applications that are filed after your initial application can essentially graft on to your initial application additional goods and services, but those extension applications are costly, they're cumbersome, and multiple applications for the same mark can lead to administrative headaches down the road. So we encourage clients, where possible, to file for one application, one mark, covering all the goods and services of interest. Now, in some jurisdictions, such as China, for example, multi-class applications are not permitted. And so if you wish to file an application for a mark in 3 classes, it will require 3 separate applications. In looking at the goods and services, you may also need to think about what, in fact, are the goods and services? How would you describe them to the trademarks office? The trademarks office requires goods and services to be described in ordinary commercial terms, layman will. So it's important to distill what it is, in fact, you're offering to simple, common, easy to understand terms. One further thing to think about is whether you're going to be offering the same goods and services in all the same jurisdictions of interest. Whether for business or regulatory reasons, you may not want or even be able to offer the same goods and services across all markets. It's a time-consuming process, but tailoring the scope of your national applications to the specific jurisdictions can save you money and save you from non-use challenges down the road. So consider the US, for example. In the US, cannabis products cannot be included in trademark applications. It is filed in Canada and covers cannabis products. That's fine. However, seeking to obtain the corresponding protection in the US is going to be problematic. If your application is based on use in the US, use must be shown before your application proceeds to registration. Such is not the case in Canada. You do not need to file specimens of use to perfect your application before registration. So in the US, if you file a omnibus application covering a great many goods and services, you better be prepared to, in fact, use the mark in association with those goods and services before obtaining your registration. So overbroad applications are expensive. They're going to get even more expensive as of January 1st. I understand the USPTO is going to increase its rates considerably at the start of next year. And these applications may be subject to abandonment if you do not, in fact, use the mark in association with those goods and services by your final deadline. So turning to the last key parameter, key jurisdictions. Ask yourself, what's your plan for world domination? In which markets are you currently using the mark, either directly or indirectly through licensees? But where do you see the business going In which markets do you plan to expand in the future? Where do you want to be in 3, 5 years' time? What are your competitors doing, and where is the market going? These are things to consider in putting together your global filing strategy. Canada and the US, they're a natural pairing. We're each other's biggest trading partners with nearly $3.6 billion worth of goods and services crossing the border each day. So, of course, if one seeks to do business in Canada, the natural extension is the US and vice versa. And rarely do you see a brand owner in one jurisdiction not also operating in some capacity in the other. But looking elsewhere to South America, the UK, the EU, and Asia, it may be a different story. You may have different considerations, different priorities. While Asia may not be a market of immediate interest, you may wish to nevertheless file in China to enforce your rights both in the IP office and with Chinese customs officials. It's no secret that the majority of counterfeit goods come out of China. And so in order to protect your brand from counterfeiting, it's always a good idea to consider filing in China, if only to protect yourself and your reputation. But as we'll see shortly, where you plan to grow your business will help to determine what filing system you choose to use. And with that, I'll turn it over to my colleague, Olivier, to talk a little bit about clearance searches.
Thanks, Graham. As lawyers, I think we're naturally a bit risk averse, and clearance searches is a topic that we tend to love to talk about. It's not our first presentation on searches, and it's not going to be our last. But in the context of crafting a global filing strategy, I really do think that they are critical. So first, to make sure that we're on the same page, what do we mean when we say a clearance search? What we mean is taking a look at the trademark registers of all of the jurisdictions of interest to identify, and potentially a search of the marketplace as well, to identify third-party prior applications, registrations, or common law marks, so marks that are used but are not registered, that could constitute obstacles to your project in those countries. And what I mean by that is there's three main things that the searches are going to help us with. The first is identify the risks of using the trademark in that jurisdiction, regardless of whether you're actually going to file your trademark application or not. So if the plan is to use a new trademark in Japan, you'd like to know if there's a risk that someone is going to sue you for trademark infringement in Japan. So those are the risks to use the trademark. The other key thing is that searches help you determine the likelihood of successfully registering the mark, or to say it differently, the likelihood that there's going to be obstacles during the prosecution of the application in the form of objections from the trademark office or oppositions from third parties. And when I tell this to clients, often the first thing that they reply is hey, Olivier, if there's an obstacle during the prosecution, we'll deal with it if and when it happens. But I think if there's one thing that you have to keep in mind with searches is that the benefit is that by identifying obstacles proactively, you can adjust to them and mitigate the issue. So for example, if the plan was to file for a word mark in Canada and the US and Japan, in black and white, like Graham advised, and you do your searches and you realize that in Japan, there's going to be an application or registration of a third party that's going to block your application. Then maybe in Japan, instead of filing for the application in black and white, you pivot and you file for composite mark that's going to be the mark in color with fanciful design. That's going to reduce the risk that there's going to be obstacles. And so by spending a little bit of money on the searches and being proactive, you end up potentially saving costs on an opposition down the line. Now, searches have a ton of other benefits, like determining the scope of protection to which your trademark will be entitled in all of the countries of interest, and importantly, determining whether the trademark has negative connotations in the countries of interest. That being said, I don't want to spend too much time talking about the benefits of searches, not because I don't think they're critical, but because I think it's a non-issue. Instead, I want to take a step back and spend a bit more time to talk about what I think is the more interesting question, which is how do you craft a cost-effective filing strategy? Because the best case scenario, the ideal strategy, at least for a trademark lawyer, is you conduct comprehensive searches in all of the jurisdictions of interest. You leave no stone unturned, and you make sure that you have a complete and thorough understanding of all the potential conflicts. But the reality is that for the vast majority of companies, for the vast majority of applicants, that's just not reality, right? You have some budget constraints. Your proverbial wallet is not unlimited, so you have to make practical choices and you have to prioritize. And in those situations, there's a long list of factors that we consider to help us determine when it's okay to scale back and where we really need to double down. So for example, what's your risk tolerance? Are you okay with some level of risk, or do you have partners or investors that require you to be very strict about risk management? What's your adaptability? If you're commercializing and you receive a cease and desist letter, how quickly can you adapt? How quickly can you stop using the trademark altogether? Other factors are very market specific. So cost of searching. In Mexico, I got a quote 2 days ago. A search is about $300. In the US, it's 10 times that, right? But then there are different markets, and the US is a much bigger market than Mexico, so you have to factor that in. Recognition of common law rights. If we're talking about a common law country where you can acquire rights in a trademark through use, even if you have never filed for a trademark application, then you're better off doing a search of common law rights. So business name, domain names, and marks that are used but not registered, because some third parties could have rights that are not on the trademark database. In civil law countries where common law rights are not recognized, maybe it's less of an issue. Launch timing. Are you currently using the trademark? Because if so, you better do you should do the searches, because there's actually a risk that you're going to be sued for trademark infringement if you've never made any risk assessment. Or maybe you've used a trademark peacefully for 20 years and then it's a whole other story. Or maybe you won't be using it for the next 5 years. And then maybe it's fine to file the application and wait to see if the trademark examiner is going to cite any prior applications or prior registrations, and wait to see if there's going to be any oppositions, because you're not using the mark, right? So you're not infringing any rights. Commercial value of the trademark, that's something that Graham mentioned. Are we talking about a tagline that's going to be used for Black Friday, or are we talking about a complete rebranding effort of your main trademark? So overall, just a big list, and those are just a few factors that we look at to really craft a cost-effective strategy that aligns with your business objectives. Now, once you've determined your key parameters and you've conducted your searches, assuming the results are positive, the next step is to actually do the fun part, which is to file the application. And then you have two options. The first option is to file national distinct application in each of the jurisdictions of interest. So if you're looking for protection in Canada, the US, Mexico, and Japan, you file a national application in Canada, a national application in the US, and same thing in Mexico, same thing in Japan. The alternative is that you rely on multinational systems that, through one application, provide protection in multiple countries. So we're going to dive in all of the different options and look at the pros and cons. So national filing systems. again, I think it's the most straightforward way to get a registration. And because of that, it's typically the fastest way to registration. I say typically because there are some countries, including Canada, not to name it, that examine international applications a bit faster. But for the vast majority of countries, at least to my knowledge, national applications are going to be examined faster. Another key benefit, and that's something that we tend to overlook, is the ability to tailor each application to local practice, your business objectives, and the results of the searches. So again, if you're planning on filing an application in Canada and another one in France, well, practices are very different. In Canada, they're very strict about goods and services, so yeah, your description has to be very narrowed, and it's the complete opposite in France, right? So you have the ability to tailor it to tailor your applications because they're completely distinct. Or again, to use my previous example, maybe in the context of searches, you realize that there's no obstacles in Canada and the US, but you have a big obstacle in Japan. Then maybe you go with your plan A in the US and Canada, but you pivot and you decide to file another mark in Japan, right? So it's this ability to be flexible that you have with national applications that you don't have with multinational systems, because it's a one size fits all system. The obvious drawback of national systems is that you inevitably have to hire local counsel. We typically do that for you through our network of foreign associates, but that typically drives costs and is going to increase the paperwork, because some countries are going to need power of attorneys, some countries are going to need translations, so on and so forth. The second system is our regional filing systems, which provide protection in multiple countries within one region. And the best example that I can give you is the European Trademark Office. So if you want to secure a trademark registration in European countries, you have the option to file national applications. So a national application in France, in Germany, in Spain, so on and so forth. But you also have the possibility to file an application through the European Trademark Office, which is going to provide protection in all of the countries of the European Union. The obvious advantage is that because you're filing only one application, it's most likely going to be more cost effective if you're looking at multiple countries. It's going to be much less paperwork. Again, you only hire one local counsel, and he's going to file he or she's going to file the application for you, and that's it. The two disadvantages is that you have less flexibility. Again, it's a one size fits all, and if your rights in the European trademark are jeopardized, then the rights are jeopardized in all of the countries of the region, right? Which is very different than if you had national applications. If there's an issue in France and you have a national application, that's the only issue, right? And your application in Germany is not impacted. You always have the option to convert your, in this case, the European trademark application to national applications, but it's not automatic. The deadlines are tight, so it's just something that you have to keep in mind. Finally, the Madrid filing system. So the Madrid filing system is a international system administered by the World Intellectual Property Organization that allows applicants, through the filing of one application, to secure protection in I think up to 130 countries. And the way it works is it's a two-step process. So the first thing you have to do is to file a national application in your home country. So I think it has to be either your home country or a country where you have a real and effective commercial establishment. And once you have this application or this registration, you're going to file an international application that's going to be based on this home application, and then you're going to extend to all of the countries of interest. And it's going to be examined under local laws. The obvious advantage is that you don't need to retain local counsel. If you're based in Canada, we can do that for you. It's one lawyer, so it's going to be much less paperwork, and it's typically going to be more cost effective. And I say typically because there are some fees to file an application through WIPO, and those fees are only going to be offset if you're considering protecting your market in at least 4 or 5 countries. So typically that's the tipping point, and it depends on the actual countries, but around 4 or 5 typically you better off going with Madrid. And then at the end, if you secure registration, it's one application, right? So it's much easier to manage. The main disadvantage is, again, the same as regional applications, is that you have less flexibility, right? It's a one size fits all. And importantly, because your international application, where you're going to designate a bunch of countries, is going to be based on your home application, it's always going to be limited by that home application or that home registration. So if your home application is limited in scope, the resulting international application is going to be limited in scope. And for the first 5 years, if something happens to your home application or home registration, so if it's opposed, invalidated, or if there's an issue, that's going to be an issue for your international application as well. Again, here you're going to have the option to transform your international application into national applications in all of the countries of interest. But it's not automatic, and it's something to keep in mind. So 3 very different systems that have their pros and cons. And yeah, over to you, Graham.
Thank you, Olivier. So in conclusion, some best practices, some recommendations. We encourage brand owners to take the long view, to consider very carefully what you want to be, where you want to be in 3, 5, 10 years from now. Unfortunately, our trademarks office here in Canada is experiencing a significant backlog. It's taking longer than usual to get through applications, to examine applications. And so applications may not be even examined for 2, 3 years' time. So it's important to bear in mind where you see yourself over the long haul, and prepare and file accordingly. And also, to Olivier's point, conduct thorough clearance searches. Identify obstacles not only to registration on the local IP registers, but also obstacles to use. Identify these conflicts early to allow yourself the time to adjust your filing strategy accordingly. Maybe it's a matter of removing certain goods and services from your local applications in order to avoid an anticipated objection. Something like that is much easier to do before rather than after. And then leverage multinational filing systems. Olivier identified 3 different filing systems, each with their own advantages and disadvantages that will serve you well depending on what you're looking to do and where. So a national filing system, a regional filing system, and of course the Madrid filing system can all serve you depending on your business objectives. And with that, we'll turn it over to questions. I see we've already received a few. Olivier, this one's, I think, for the 2 of us. While some jurisdictions may not be of interest for now, if you don't want third parties to register an identical mark to yours, do you recommend keep filing your own marks in those jurisdictions? In which case, after 3 to 5 years, registered marks will become vulnerable and need to be refiled for identical or similar marks down the road. Wonder what you think about this as a global strategy and what other options you might have.
It's a good question, right? And Graham, I don't know what you think. It's probably dependent on the different countries, because different countries have different practices and different laws. I'm sure in some countries, just filing and maybe I misunderstood the question, but filing applications over and over again without having any use could be considered bad faith, which I guess could be an issue. And I don't know if you have any other thoughts.
My immediate thought is it seems like an expensive strategy.
That too, yeah.
We talked about controlling costs, and of course that's a key consideration of any filing strategy. But to your point, I think you need to look at the jurisdictions of interest and ask yourself, so why are we concerned with these jurisdictions? If we're not using the mark in these jurisdictions, do we want our mark on the register for defensive purposes so other people cannot apply for it? Do we want it to rely upon in case we need to, say, file a notice and takedown in that jurisdiction? Um, and and if you're there for defensive purposes only, I think you need to think about what's the real value. If it's not a market of interest now and never, then perhaps the money and efforts are better spent elsewhere. In terms of other options, I know that firms around the world, including ours, offer watch services. So we can take a look at the register and monitor the register on an ongoing basis for any third-party filings of interest or concern. And this is something that can be done around the world. So if you don't necessarily have vested interests in a mark in the market at the time, but you have your eye on the market. Nevertheless, you wish to do something about third-party filings. You can hire your local counsel to monitor the register and alert you when something comes in of interest.
I have another interesting one for you, Graham. For countries with specific goods and services requirements like US and Canada, do you recommend Madrid having these as a base application, given that the ideas for these countries are more narrow, as this might narrow the recitation and designations where more liberal recitations are allowed? And it's a great question, right? Because in Canada, which I think is the more stricter, I don't know, a country for what I know in the world, it's definitely going to impact your recitation in other countries. So it's definitely something that you have to consider. And to my knowledge, you can do some forum shopping in the sense that if you have real and commercial effective business in other countries, then maybe you can file from your base application in France if that's where if you have real operations. Otherwise, yeah, you're a bit limited by where you're operating, and it's definitely going to impact your coverage. I don't think, and tell me if you work differently, Graham, it hasn't prevented us in the past from filing from Canada. It's just something that you have to keep in mind when you craft your specification of goods and services.
I think that's exactly right, Olivier. I know our examiners in Canada are very, very particular, sometimes frustratingly so. And so I think it is a good idea to start broad, and perhaps that means filing an application for international registration based on an EU TM application, where the scope of goods is a bit broader. The specificity is a little more lax or liberal, and then narrowing accordingly. Of course, protocol applications based on the underlying home applications or registrations have to be as specific, if not more specific, than the IR itself. And so you can only get narrower. You cannot go broader. And so it's, I think, a good idea to look for the broadest possible home application and registration.
And another, I won't say easy one, what countries beside the US have common law rights? And how do you recommend searching in those countries? Are they typically more expensive countries to search?
So I know the Commonwealth countries will have common law rights. So the UK, Australia, they're typically more expensive only because you're expanding the scope of your search. You're looking not only to the register, but also to the marketplace itself. And that could mean a number of different things. That could be Google searches for local traders. That could be in the field investigations, which of course cost even more money if you're interested in what are the marks in use in the marketplace. So typically, searches of that nature are a bit more expensive. There are a few more stones to overturn.
I'll even add that the scope of the common law search is going to depend on the nature of the goods. So if we're talking about pharmaceutical products, then we're going to want to look at, you know, the database of the FDA, the database of Health Canada, because there could be relevant hits. And so those are databases that we would never look at if we're you know, looking for a trademark in association with shoes, right? So we always say there's two types of searches, register and common law. It's a bit more complicated than that. And there's really the ability to tailor it to your needs.
We have another question about applications in the US based on home applications in Canada. Does use still need to be proved, providing samples in the USA, if your home application is in Canada? So I think it's a two-parter, really. If your national US application, and I'll preface this by saying I'm not a licensed US trademark attorney, but having worked extensively with US attorneys, it's my understanding that if your US application is based on use and registration in Canada, you could theoretically register your mark in the US without providing specimens of use, providing instead merely the registration certificate that issued in Canada. If, on the other hand, you're designating the US as a protocol application based on a Madrid home application through the Madrid system based in Canada, I believe that you will nevertheless need to use or need to provide specimens of use at the conclusion of the application process in order to perfect the application, as it's essentially treated as a national application in the US.
Talking about the US, someone is clarifying that the new fees kick in January 18, so thank you for that. Should you always search and file your trademark in black and white? So you talked about filing a trademark and in black and white for better coverage, at least most of the time. How about searches? I don't know what you do, Graham. The way I've always done it is you search for exactly what you're doing. So if you're using a trademark in color, that's what you're going to search, because it's a risk assessment, right? You want to know if what you're going to do is going to be problematic. But then for the searches, for the filing, if you can only file one, you file in black and white, because that's going to give you the broader protection. So you search exactly what you're doing and you file in black and white for broader protection.
Yeah, I've always favored basic word marks in black and white simply because they offer the best scope of protection. But that said, with the latest changes to the Trademarks Act that came into effect in 2019, you know, we now have available the broadest scope of registrable trademarks, I think, in the world, provided that you can demonstrate distinctiveness. You could apply for and register as a trademark a color, for example. So if color is a key component of your brand identity, if you only ever use your word mark or your design mark in a particular color or combination of colors, then there is good reason to claim color, because that it serves only to reinforce your rights in that color scheme. So actually, with that, we have one last question about the differences between words and designs. So if the broader protection is for the word, why then register the design in a global cost-effective strategy? And it's a great question. I think there's a difference to be noted between a word mark and a stylized word mark, and a word mark and a design mark that might have a logo, for example. if you're simply using a word mark in a particular style, then perhaps it's best to simply file for the word mark, because as we all know, brands change over time, they evolve, and what may appear in an italicized typeface, in the first 5 years of a brand's life cycle may change into a bold typeface in the subsequent years. So I think word marks offer the broadest scope of protection, but designs, I think, are nevertheless important, and it comes down to how you plan to deploy the mark. If you're looking to deploy the mark and use it in the marketplace, always in conjunction with the word, then perhaps you file for what's called a lockup, or a composite mark that consists of both word matter and design matter. Or you can file the two separately if you will be using them in various iterations and combinations. So it really does come down to how you plan to deploy the mark, how you plan to use it in the marketplace, not only next year, but 3 years, 5 years down the line.
Yeah, and I emphasize, talk with your marketing team. Make sure that what they sent you by email of the new trademark that needs to be registered is actually something that we're going to use long term. Are we going to change the colors? Are we going to change the design? Is it just something right now and we're going to do rebranding next year? I think you'd be amazed to see how many times that there's some misunderstanding and we end up filing something, and even before we get the trademark registration, we're already at we have already done many iterations. So I think that's a good tip to keep in mind.
And that's a great point, Olivier. I find it comes up quite often in my practice as well. It's amazing the time and attention and resources that are spent protecting, what you may have described as a Black Friday tagline that is used only for a very brief period of time, when, those resources may be better spent protecting primary trademarks, brands with a little more shelf life. So that's always something to bear in mind. How often and for how long will you be using this mark? Is it worth the investment? And with that, I guess we've reached the end of our Q&A session. So thank you all very, very much for your participation, your insightful questions. As a reminder, when the webinar ends, a survey link will pop up on your screen. We greatly appreciate your taking a moment to share your feedback. And looking ahead, next Tuesday, November 26th, our trademark team will host another webinar on the impact of Bill 96, the French language law on product trademarks. So if you're interested and haven't registered yet, we encourage you to visit our website, smartbiggar.ca, to sign up. Thank you again for joining us today. We hope to see you at our future sessions.